Welcome to today's deep dive. I am so glad you could join us today because we are unpacking a really fascinating, honestly, almost paradoxical legal
It
puzzle.
really is a paradox.
Right. We're looking at the 1998 California Supreme Court case, People v. Davis, along with, the centuries of historical common law precedents that it relies upon. And here's where the situation gets really interesting for you as the listener. How exactly does a routine retail store turn in to common law larceny, especially when the quote-unquote thief never actually leaves the store with the merchandise? What happens legally when you try to sell a store its own property?
Yeah, that is the exact puzzle we're going to unravel for you today. Our analytical path will systematically dissect the 6 black-letter elements of larceny. We will specifically zero in on the doctrines of trespassery taking and intent to steal. And to do that, we are going to explore the common law rule of animus ferandi, which translates to the intent to permanently deprive. Along the way, we'll analyze the 3 major categories of exceptions to this rule. Those are the sale, reward, and refund cases. By the end, you'll see exactly how courts untangle this whole web.
Okay, let's unpack this by starting with the foundational definitions. We hear the word theft thrown around a lot, but how exactly does California define it? And what is the black letter rule for larceny?
So under California Penal Code Section 484, the state actually consolidated several previously distinct offenses, basically to stop clever lawyers from getting guilty clients off on technicalities like arguing they were charged with the wrong specific crime. The state decided that theft now formally consolidates larceny, embezzlement, and obtaining property by false pretenses into one single overarching crime.
Got it. Let's analyze People v. Ashley. First, what are the legally dispositive facts?
All right, so following that 1927 statutory consolidation of theft offenses, the court in Ashley reviewed a judgment where a defendant was convicted of theft based merely on a general verdict of guilty. The jury didn't specify how he stole, just that he did. This raised serious questions about whether the substantive differences between those old distinct crimes still mattered, or if they were just, washed away.
And what was the core legal issue?
The issue was whether the procedural consolidation of theft offenses in 1927 abolished their substantive legal distinctions. Did the state just create one giant blurry crime, or did the old definition still apply?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule they established has one primary requirement. A judgment of conviction of theft based on a general verdict of guilty can be sustained only if the evidence discloses the elements of at least one of the consolidated offenses. So the single testable element is establishing all the specific elements of a traditional underlying offense, such as larceny.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, establishing an underlying offense?
The court determined that while procedural distinctions were abolished to make charging easier, the substantive legal distinctions were definitely not. To satisfy this element proving an underlying offense, the prosecution must still prove the specific unchanged elements of a traditional theft offense. The court applied this by stating that for larceny, the prosecution must prove 6 precise things. 1, the defendant takes possession. 2, of personal property. 3, owned or possessed by another. 4, by means of trespass. 5, with intent to steal, that's animus ferandi. And 6, carries the property away, which is the asportation requirement where even the absolute slightest movement counts.
And after analyzing all the elements, what was the court's final conclusion?
The conviction requires proving the specific elements of at least one underlying offense like larceny, meaning the substantive legal boundaries of larceny remain completely intact in California.
So what does this all mean for that fourth element you mentioned, trespass? In property law, we usually think of trespassing as, walking onto someone's lawn. But if a self-service store allows customers to carry items around in their hands or in a cart, haven't they consented? How can there be a trespass if the store literally lets you hold the merchandise?
What's fascinating here is how the law views the scope of consent. The act of taking personal property is always a trespass unless the owner freely and unconditionally consents. But in a retail environment, that consent is highly specific. It is absolutely not a blank check.
Let's analyze State v. Higgs. First, what are the legally dispositive facts?
Oh, this is a great Brazen Ohio case. A defendant walked into a Sears store, took a toy airplane from a retail display, and concealed it in a paper bag he brought with him. He didn't head for the exit, though. He walked right up to a cashier, claimed the toy was a gift for his son that he wanted to return, and actually received a cash refund.
Wow.
Yeah, and the kicker is that store security agents watched the entire thing unfold on camera from the exact moment he picked up the toy.
That takes some nerve. And what was the core legal issue?
Did the store's general consent to let customers carry merchandise, combined with their authorized agents consenting to issue a cash refund, vitiate or legally erase the trespass element of larceny?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the common law rule for a trespass retaking. The rule states that the act of taking property from the possession of another is a trespass unless the owner consents freely or the taker has a legal right. The elements to test here are first, the physical taking of the item, and second, the absolute absence of relevant consent from the owner.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the physical taking of the item?
The sub-issue was identifying exactly what was taken. The defendant tried to argue the theft was the money given during the refund, but the court established that the item unlawfully taken was the toy airplane itself. The physical taking occurred the exact moment he removed the toy airplane from the merchandise display and concealed it in his bag. The element of physical taking was definitively met.
Understood. Now, what about the second element, the absolute absence of relevant consent?
The sub-issue here was whether the store's open layout and the cashier's processing of the refund counted as consent. The court reasoned that while a retail store implies consent for customers to handle merchandise for the purpose of purchasing it, it manifestly does not imply consent to conceal merchandise in a bag to return it for cash. Furthermore, the fact that Sears permitted the actual refund while watching on camera was legally irrelevant to the theft of the airplane. The store never consented to the taking of the airplane for the purpose of stealing it. Therefore, relevant consent was entirely absent.
And after analyzing all the elements, what was the court's final conclusion?
The court affirmed the larceny conviction, concluding that consent to handle an item depends entirely on the specific intent of the taker. Handling an item to steal it is a trespass, regardless of store policy.
That brings us perfectly to the fifth element, the intent to steal, or animus furandi. You mentioned this requires an intent to permanently deprive. But what if the deprivation is meant to be temporary? What if the thief actually intends to give the property back?
This is where the law has to get creative. The general rule is that the word permanently is not to be taken literally. If it were, thieves could find loopholes everywhere. So courts have developed exceptions where the required intent to steal exists, even if the primary purpose isn't permanent deprivation in the traditional sense.
Let's analyze Regina v. Hall. First, what are the legally dispositive facts?
This is a classic English case from 1848, and it paints quite a picture. The defendant, Hall, was an employee of a candle maker named Atkin. Hall took a large quantity of Atkin's own rendered animal fat called tallow, which was highly valuable for making candles, and placed it on Atkin's scales. He then attempted to sell the tallow back to his employer, lying and claiming it belonged to a neighboring butcher who was offering it for sale.
Trying to sell a man his own candle wax. And what was the core legal issue?
Did the defendant's assertion of only temporary ownership over the property, specifically for the purpose of selling it back to its true owner, constitute the required intent to permanently deprive?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied what we now call the sale exception. The rule is that taking property with the intent to sell it back to the owner constitutes the intent to permanently deprive. This relies on testing two rationales as sub-elements. First, the conditional nature of the deprivation, and second, the assertion of ownership rights.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the conditional nature of the deprivation?
The sub-issue was whether the property was actually gone forever. Barron Park reasoned that the deprivation actually was permanent, unless the owner agreed to the thief's condition. The intention was that the tallow should never revert to the owner unless the owner chose to buy back his own property. Because the fat was completely severed from the owner pending that financial transaction, the court found this first element met.
Understood. Now, what about the second element, the assertion of ownership rights?
The sub-issue was whether Hall's actions demonstrated animus furandi. Chief Justice Denman addressed this directly. He reasoned that asserting a right to sell the property is the ultimate proof of asserting ownership over it. You simply cannot sell something unless you claim to own it, and claiming that ultimate right of ownership satisfies the intent to steal, even if you are selling it to the rightful owner. So the second element was also met.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was upheld. Taking property to force the owner to buy it back establishes the intent to permanently deprive.
Okay, so we've seen how forced sales count as theft. But what if the thief doesn't want to sell it back? What if they just want to hold the property hostage to claim a reward? That feels slightly different than a forced sale.
It is different in its execution, but you'll see it's incredibly similar in legal theory. The courts look very closely at the pecuniary or financial interest the thief is trying to extract.
Let's analyze Commonwealth v. Mason and Slaughter v. State. First, what are the legally dispositive facts?
These two cases perfectly illustrate the reward problem. In Mason, an 1870 case, the defendant took a stray horse that wandered onto his property and deliberately hid it. He intended to wait until the owner offered a cash reward, or to induce the owner to sell the quote-unquote lost horse to him for less than it's worth. In Slaughter, it's even sleazier. Corrupt private detectives actually induced a retail employee to steal merchandise from a store, and then the detectives returned the stolen goods as evidence to persuade the store owner to pay them a handsome reward for catching the thief.
Those are wild scenarios. And what was the core legal issue?
Did taking property merely to extract a reward for its return constitute an intent to permanently deprive the owner?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
Both courts applied the portion of value reward rule. The black-letter rule is that it is sufficient if the property is taken with the intent to appropriate any pecuniary right or interest therein. The single testable element is intent to appropriate a portion of the property's financial value.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the intent to appropriate a portion of the property's value?
The sub-issue is whether a reward counts as part of the property itself. The courts reasoned that a reward inherently represents a portion of the property's overall value. In Mason, hiding the horse to extract a reward meant intending to deprive the owner of that specific pecuniary value. Similarly, in Slaughter, returning the merchandise was just a vehicle to appropriate a pecuniary interest, the reward money. You do not need to permanently appropriate the physical property itself if you permanently appropriate a financial interest tied to it. The element was clearly satisfied in both cases.
And after analyzing all the elements, what was the court's final conclusion?
The larceny convictions were affirmed in both cases. Taking property to claim a reward fulfills the intent to steal by appropriating a portion of its value.
Let's look at another reward case to solidify this. Let's analyze Berry v. State. First, what are the legally dispositive facts?
In this Ohio case, defendants took 2 horses from a stable without the owner's consent. Their calculated plan was to conceal the horses until a reward was offered, and only then return them to claim that money.
And what was the core legal issue?
Did the intent to return the horses, which the defendants argued was only a temporary deprivation, negate the intent to steal?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the contingent return reward rule. The rule states that a purpose to return property founded wholly on a contingency constitutes an intent to permanently deprive. The testable element here is whether the intention to restore the property is unconditional or contingent on payment.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, whether the intention to restore was unconditional or contingent?
The sub-issue was analyzing the thief's exact state of mind regarding the return. The court observed that there was an utter absence of intention to restore the property unless money was paid. A return at all events was not designed. Because the intent to return was founded wholly on the contingency of a reward being offered, the legal conversion of the property was complete the very moment they took the horses out of the stable. The element of a contingent return was met.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was affirmed. Unless a return is completely unconditional, a contingent return equals an intent to permanently deprive.
Okay, bringing all of these historical quirks into the modern era, how do modern courts handle retail refunds compared to these common law sales and rewards?
They often apply modern statutes, but they face the exact same logical hurdles regarding intent and control.
Let's analyze State v. Martin and People v. McLemore. First, what are the legally dispositive facts?
In Martin, a defendant took 4 shirts from a store display, carried them straight to a counter, asked for a refund claiming they were gifts, and actually received a receipt before being detained. In McLemore, it's a bit more aggressive. The defendant brought a dress bearing an electronic anti-theft sensor to a clerk for an exchange. When the manager demanded a receipt, the defendant got angry, insisted the dress was his, and simply walked out of the store with the unpaid dress.
And what was the core legal issue?
Did claiming ownership for a refund constitute theft of the merchandise itself? And did it demonstrate intent to deprive?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The courts applied rules focusing on statutory exertion of control and the practical risk of permanent loss. The rule breaks down into two testable elements. First, exerting control contrary to the owner's rights, and second, creating a substantial practical risk of permanent loss.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, exerting control contrary to the owner's rights?
The sub-issue was how someone exerts control without leaving the store. In Martin, the court found that by telling the clerk the shirts were gifts, the defendant exercised verbal control and concealment. Claiming ownership to get financial consideration exerted control over the shirts in a manner totally contrary to the store's actual ownership. So the first element is satisfied by mere words.
Understood. Now what about the second element, creating a substantial practical risk of permanent loss?
This sub-issue is where McLemore is crucial. The courts recognize human nature. If a fake refund is rebuffed, the thief has a powerful incentive to keep the item to avoid drawing further attention. In McLemore, when the refund failed, the defendant didn't politely put the dress back on the rack. He walked out with it. Demanding a refund creates a massive practical risk that the store will lose the property permanently if the scam fails. Thus, the second element was met.
And after analyzing all the elements, what was the court's final conclusion?
The convictions were affirmed. Exerting verbal control for a refund and the practical risk of loss if the refund fails satisfy the elements of theft.
Okay, let's bring this all together. Let's analyze People v. Davis. First, what are the legally dispositive facts?
Kenneth Davis walked into a Mervyn's department store carrying a shopping bag. He was filmed taking a shirt from the men's department and carrying it all the way to the women's department. He told Cashier Smith he bought it for his father but lacked a receipt because it was a gift and asked to return it. Instructed by store security agent German, the cashier issued a credit voucher. Davis signed it with a false name and was detained by security as he was walking away.
And what was the core legal issue?
Did Davis's act of taking the shirt to the register lack the intent to steal? And did his act of accepting the voucher lack trespass because the store's agents consented to the transaction?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the consolidated theft rule for larceny that we discussed at the beginning, requiring all 6 elements. 1. Takes possession. 2. Of personal property. 3. Owned or possessed by another. 4. By means of trespass. 5. With intent to steal. And 6. Carries it away.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, takes possession?
It was completely undisputed that Davis took physical possession of the shirt from the display rack. Element met.
Understood. Now what about the second element, of personal property?
Again, undisputed. The shirt was tangible personal property. Element met.
Understood. Now what about the third element, owned or possessed by another?
Undisputed that the shirt was owned by Mervyn's department store, not Davis. Element met.
Understood. Now what about the fourth element, by means of trespass?
Davis argued the store consented by issuing the voucher. The court rejected this, analyzing the exact moment of the taking, just like in the Higgs toy airplane case. The sub-issue is specific intent. The store impliedly consents to customers handling items to purchase them. Mervyn's manifestly did not consent to Davis taking the shirt with the intent to steal it. The trespass occurred the moment he took it from the rack. Element met.
Understood. Now what about the fifth element, with intent to steal?
Davis argued he only wanted to temporarily deprive the store of the shirt to get a voucher. The court synthesized the sale, reward, and refund precedents we just covered. By demanding a refund, Davis made an assertion of ownership. His intent to return the shirt was founded wholly on the contingency of receiving a refund. Because the return was conditional, it legally constituted an intent to permanently deprive. Element met.
Understood. Now what about the sixth element, carries it away?
The sub-issue is asportation. The asportation requirement is met by the absolute slightest movement. Davis carried the shirt across the store from the men's department to the women's department, which easily satisfies this movement element.
And after analyzing all the elements, what was the court's final conclusion?
The California Supreme Court affirmed the conviction. A conditional return for a retail refund equals the intent to permanently deprive, and handling goods with that intent constitutes a trespass retaking. Larceny is complete before you ever reach the exit doors.
That is incredible. Let me throw a bizarre, unforgettable hypothetical at you to see if this rule really holds up in the extremes. Imagine you sneak into a locker room and steal a fellow student's custom, lifelike $5,000 prosthetic leg. You don't actually want to keep a prosthetic leg. You hide it in a moldy gym locker and leave a ransom note demanding $500 for its safe return. The police catch you before the ransom is paid. You argue you only intended to temporarily deprive the student of their leg. How does the court apply the law here?
It is gross, but applying the reward and contingent return doctrines from Berry v. State and People v. Davis, your argument completely fails. Your intent to return the prosthetic leg was founded wholly on the contingency of the $500 payment. You did not plan a return at all events. Therefore, the legal conversion was complete the very moment you moved it, satisfying the asportation requirement with that conditional intent. That fulfills the animus ferandi, making it larceny.
Wow, so even with something as visceral as a prosthetic leg, the law is completely rigid there.
Absolutely. And if we connect this to the bigger picture, for anyone taking a law exam or just trying to systematically understand this, here is your actionable step-by-step diagnostic checklist for issue spotting. Step 1. Check asportation. Look for the absolute slightest movement of the property. Sliding an item an inch counts if the intent is there. Step 2. Analyze trespass and consent. Did the owner consent to the specific intent of the handling? Remember, Higgs' consent to handle a toy airplane for purchase is not consent to handle it for theft. Step 3. Scrutinize intent, the animus ferandi. Is the defendant's plan to return the property truly unconditional? Step 4. Apply the conditional return exceptions. If the return is conditional, run it through the 3 categories. Is it a forced sale like Regina v. Hall with the candle wax? Is it held for a reward like Berry v. State with the horses? Or is it a retail refund like People v. Davis with the department store shirt? If any of those apply, the intent to permanently deprive is firmly established.
If a store's security cameras watch you conceal an item, and the store willingly lets you proceed through self-checkout just to catch you in the act, at what exact millisecond does the consent vanish and the crime of larceny crystallize in the digital age? It's a paradox that makes you look at shopping completely differently. Something for you to ponder next time you're scanning barcodes.